nearly 44% of California renters are considered rent burdened, meaning they spend more than 30% of their income just to keep a roof over their heads. In some cities, that number is even higher. Now imagine this. Your landlord can legally raise your rent by hundreds of dollars with proper notice, and it could happen faster than you think. No warning signs, no dramatic headline, just a letter on your door. And suddenly, your monthly budget is in crisis. Over the past year, rent rules across California have quietly shifted, and many tenants don't even realize how these changes affect them. Some protections have expired, certain buildings are exempt, notice periods can vary, and depending on where you live, what you think is illegal might actually be perfectly allowed under state law. Confusing? Absolutely. And that confusion is costing renters money. So, what exactly changed? Who is protected and who isn't? Stay with me because the next few minutes could save you thousands of dollars and protect your housing stability. Number 1. Faster rent increases under state caps. Here's something most renters don't realize. Under California's statewide rent control law, landlords can legally raise rent by 5% plus inflation every single year, up to a maximum of 10% annually. That's not a rumor, that's written into state law. And in years, when inflation rises, that increase can feel like a financial earthquake. Picture this, you're budgeting carefully. Groceries are up, gas is up, utilities are up. Then one day, you receive a formal notice. Your rent is increasing by $220 per month. That's over $2,600 more per year without you moving, upgrading, or changing anything. For many households already stretching every paycheck, this kind of jump can push a stable situation into a crisis. What makes this more challenging is that these increases are completely legal as long as they follow the cap and proper notice rules. Many tenants assume rent can't go up that much, but the law allows it. And if you don't calculate the numbers yourself, you might not even realize whether the increase is accurate. So, what can you do? First, find out your local CPI, Consumer Price Index, because that affects the allowable percentage. Second, carefully review the written notice, timing matters. And third, don't be afraid to politely ask your landlord for a breakdown of the calculation. Understanding the math behind your rent increase gives you something powerful: control. And in today's rental market, control is everything. If this information opened your eyes, drop your city name in the comments. We read every single one. Wait, and it helps us create videos tailored to you. We put serious effort into breaking this down simply. So if you value that, hit subscribe. It's just one click, but it makes a huge difference for this channel. Number 2. Local protections are expiring. During the pandemic, millions of California renters were protected by emergency eviction rules, rent relief programs, and temporary local ordinances. Cities and counties stepped in with strong safeguards that gave tenants breathing room during uncertain times. But here's the part that's catching many people off guard. A number of those protections have quietly expired. That means rules you may have relied on last year, longer notice periods, special hardship protections, or stricter eviction requirements, might no longer apply today. And the expiration didn't always come with a big announcement. In many cases, protections simply phased out as emergency declarations ended. Imagine assuming you still have extra time to catch up on late rent, only to discover that the extended grace period is gone. Or believing your city still blocks certain eviction types when legally it no longer does. That misunderstanding can cost tenants thousands of dollars or worse, their housing stability. What makes this even more complicated is that California rental law isn't just statewide, it's layered. You have state law, but you may also have county rules and city specific ordinances, and they don't always match. Some cities maintain stronger protections, others have reverted fully to standard state regulations. So, what should you do right now? Visit your city's official housing department website. Look specifically for updates labeled tenant protections or eviction protections. Don't rely on old information or social media posts from months ago. Laws change, and fast. When it comes to housing, outdated information can be just as dangerous as no information at all. Staying informed isn't optional anymore, it's essential. If this helped clear things up, comment checked once you've reviewed your local rules. We genuinely want to know who's taking action. We work hard to simplify complex laws. So if you appreciate that effort, tap subscribe. It's one click for you, but it means everything to this channel. Number 3. Newer buildings are often exempt. Here's a detail that surprises many renters. If your apartment building is less than 15 years old, it may be completely exempt from California's statewide rent cap. Yes, you heard that right. While many tenants assume rent control applies everywhere, newer construction often falls outside those limits. This exemption was designed to encourage developers to build more housing. The idea was simple: reduce restrictions on new buildings to stimulate supply. But for tenants living in these properties, the reality can feel very different. Without the annual cap of 5% plus inflation, rent increases in exempt units can be significantly higher, depending on market conditions. Imagine moving into a modern apartment complex with new appliances, fresh paint, and secure parking. Everything feels stable. Then at renewal time, you receive notice of a substantial rent increase, one that wouldn't have been allowed in an older building under statewide caps. That shock hits differently when you didn't even know the exemption existed. The key issue here is awareness. Many tenants sign leases without checking the building's certificate of occupancy date, the document that determines whether the 15-year clock applies. Landlords are required to disclose exemption status in writing, but that disclosure is often buried in the fine print. So, what should you do? Review your lease carefully. Look for language referencing exemption under state law. If you're unsure, ask directly: is this unit subject to statewide rent control? It's a simple question, but it could save you from unexpected financial strain. In today's rental market, unknowing whether your building is protected or not makes all the difference. If you're living in a newer building, comment new build below. We're curious how many of you are affected. We put serious research and effort into making these videos clear and practical. So if you value that, hit subscribe. It's just one click, and it truly helps us keep going. Number 4. Just cause evictions still have loopholes? California has what's called a just cause eviction law, which means in many situations, a landlord must provide a legally valid reason to terminate your tenancy. On the surface, that sounds incredibly protective. And in many cases, it is. But here's what most tenants don't realize: there are still loopholes that can legally end your lease, even if you've paid rent on time and followed every rule. One of the most common examples is the owner move in provision. A landlord can legally reclaim the unit if they, or sometimes a close family member, intend to move into the property. Another situation includes substantial renovations that require the unit to be vacant. These reasons are allowed under state law, but they can feel sudden and disruptive to tenants who believed they were secure. Imagine receiving a notice stating the property owner plans to move in. You've been a responsible tenant for years. You assumed just cause meant you were safe. But technically, this qualifies as a valid reason. That emotional shock, paired with the financial stress of finding new housing, can be overwhelming. Here's what's crucial: landlords must follow specific legal steps. Proper notice is required. In some cases, relocation assistance may be owed to the tenant. Documentation matters. Details matter. So if you ever receive a termination notice, don't panic, but don't ignore it either. Review the stated reason carefully. Ask for written clarification. And if needed, consult a tenant rights organization. But Just Cause offers protection, but only if you fully understand how it works. If you've ever received an eviction notice or worried about one, comment, stay informed below. We truly put time and effort into breaking down these complex laws for you. So if this helps, hit subscribe. It's just one click and it keeps this channel alive. Number 5. Higher security deposits and move-in costs are stretching budgets. Rent increases aren't the only pressure tenants are feeling. Move-in costs themselves have become a serious financial barrier. Even with recent legal limits on security deposits, in many situations, the total upfront amount required to secure a rental can still feel overwhelming. Think about it. First month's rent, security deposit, application fees, possible pet deposits, utility setup costs, moving truck, time off work. Suddenly, relocating to a new apartment can cost thousands of dollars before you even unpack a single box. In competitive rental markets, landlords are also being more selective. Some are requiring stronger income verification, higher credit standards, or additional documentation. While deposit laws may cap certain amounts, landlords often adjust by tightening screening criteria or asking for qualified co-signers. Imagine finding the perfect apartment, safe neighborhood, reasonable commute, clean and updated, only to realize the total move-in cost equals 3 or 4 months of your current rent. For many households, that kind of lump sum expense simply isn't realistic without dipping into emergency savings or taking on debt. So, what can you do? Start preparing early. Build a small housing cushion fund, even if it's just $20 or $30 per week. Keep digital copies of pay stubs and bank statements ready. Review your credit report in advance so there are no surprises. Preparation gives you options, and options give you negotiating power. In today's environment, the challenge isn't just paying rent each month, it's affording the price of entry. If you've ever been shocked by move-in costs, comment reality check below. We want to hear your experience. We put real effort into researching and simplifying this for you. So if it adds value, tap subscribe. One click from you makes a massive difference for us. Number 6. Shorter notice periods can leave tenants scrambling. One of the most overlooked challenges in California's rental landscape is how notice periods can vary depending on your lease type and how long you've lived in the unit. Many tenants assume they automatically have plenty of time if something changes, but that's not always true. If you're on a month-to-month agreement, certain situations may require only a 30-day notice. In other cases, tenants who have lived in a unit longer may qualify for 60 days. The difference sounds small, but in California's competitive rental market, 30 days can disappear fast. Think about what 30 days really means. You'd need to search listings daily, schedule viewings around work, submit applications quickly, gather paperwork, and possibly compete with multiple other applicants, all while packing and planning a move. That's not just stressful, it's overwhelming. Now imagine receiving notice right before the holiday season, or during a busy work month, or when your savings are already tight. The clock starts ticking immediately. Every day matters. The key here is preparation. First, know your lease type. Is it fixed term or month to month? Second, understand how long you've legally resided in the unit, as that can impact required notice time. Third, keep an updated folder with your rental documents, pay stubs, and references so you're ready to apply quickly if needed. Time is leverage in the rental market, and the less time you have, the less leverage you hold. Staying informed about notice rules could be the difference between a smooth transition and a rushed, expensive scramble. If you're currently month to month, comment 30 or 60 below. Let's see how many people know their notice period. We invest real time into researching and simplifying these laws. So if you appreciate that effort, hit subscribe. It's just one click, but it truly supports this channel. Number 7. Market rents keep rising. Here's something that feels almost unfair. Even with rent control caps in place, overall market rents across California continue to climb. Rent caps limit how much your landlord can raise your rent each year, but they don't reduce the starting price of new leases. And that's where many tenants feel trapped. If you've been in your unit for several years, you might be paying below current market rate. But if you're forced to move, whether due to a legal eviction reason, personal circumstances, or a major rent increase, you re-enter today's market. And today's prices are often dramatically higher than what you were paying before. Picture this. You're paying $2,100 per month in a rent-controlled unit. You have to move. The same type of apartment in your neighborhood is now listed for $2,800 or more. That's a $700 jump, not because of a yearly increase, but because of market reset pricing. Rent caps slow the growth, but they don't stop the larger housing shortage driving prices upward. Limited supply, strong demand, and population pressure all play a role. So even tenants who feel protected may be financially vulnerable if they lose their current unit. What can you do? If your current rent is manageable, consider negotiating a longer renewal term for stability. If you anticipate moving, start tracking rental listings months in advance to understand pricing trends and build flexibility into your budget wherever possible. The harsh reality is this: staying housed at a stable rate is often more powerful than finding something new. In California's rental market, stability itself has become a valuable asset. If you've checked rental listings recently and felt shocked, comment price surge below. We want to know what you're seeing in your area. We spend serious time breaking this down clearly for you. So if that effort matters, tap subscribe. It's one simple click that keeps this channel growing. Number 8. More landlords are shifting to month-to-month leases. A growing trend in California's rental market is landlords preferring month-to-month leases over fixed-term agreements. On the surface, this might seem flexible, but for tenants, it often translates into uncertainty and risk. Without a fixed term lease, your housing situation can change faster than you expect. Month to month agreements allow landlords to adjust terms, raise rent, or even end your tenancy with shorter notice periods. That means a unit that felt secure 1 month can become unstable the next. Tenants lose predictability, which makes budgeting, planning moves, or simply feeling settled far more difficult. Consider this scenario: you're comfortable in your apartment, paying your rent on time, and enjoying stability. Then, a month to month lease means your landlord can increase rent or request you vacate with as little as 30 days' notice. Suddenly, your sense of security evaporates. And in California's competitive rental market, finding a replacement unit on short notice can be both expensive and stressful. So, what's the best approach? Whenever possible, request a 12-month lease instead of a month to month agreement. This locks in your rent, gives you predictable expenses, and provides a buffer if market rates spike. If your landlord resists, emphasize the mutual benefit. Stability reduces turnover, ensures timely rent payments, and protects both parties. Flexibility for the landlord doesn't have to mean vulnerability for the tenant. Being proactive about lease type is a small step that protects your financial stability and peace of mind. If you're on a month to month lease, comment "Stay secure" below. We want to hear how many of you are affected by this shift. We pour a lot of effort into making these updates clear and actionable, so if it helps, hit subscribe. But it's just one click and it keeps this channel alive. Number 9. Stricter tenant screening. If you thought finding an apartment was tough before, brace yourself. Tenant screening requirements are getting stricter across California. Landlords are increasingly requiring higher credit scores, proof of stable income, multiple references, and even co-signers in competitive markets. For tenants, this means that securing a rental isn't just about paying rent on time. It's about proving you're perfect on paper. Why the shift? With limited housing supply and high demand, landlords can afford to be selective. Stronger screening reduces the risk of late payments or lease violations. But it also raises the barrier for many renters who might have moderate credit, fluctuating income, or simply haven't built an extensive rental history. They imagine finding your ideal apartment only to be rejected because your credit score is just a few points below the arbitrary threshold, or your proof of income doesn't exactly match the requirement. Frustrating, right? Many tenants don't realize that preparation can make the difference between approval and rejection. So, how can you improve your chances? First, check your credit report and correct any errors before applying. Second, keep proof of stable income and employment handy. Third, gather solid references from previous landlords or employers. Finally, consider a co-signer only if necessary, but make sure they understand their responsibility. By taking these steps, you can stand out from the crowd and improve your chances of landing the apartment you want, even in today's highly competitive rental market. But preparation and knowledge are your strongest tools. If you faced rejection due to stricter screening, comment "screened out" below. We'd love to hear your story. We put serious effort into breaking this down so it's actionable. So if it helps, hit subscribe. Just one click, and it keeps this channel alive for more essential updates. Number 10. Legal complexity is increasing. One of the biggest challenges California tenants face today isn't just rent hikes or deposit costs. It's the sheer complexity of rental laws. Between statewide regulations, county rules, and city-specific ordinances. It's easy to assume you're fully protected when, in reality, the legal landscape can shift beneath your feet. Even well-informed renters can misinterpret the rules, which can lead to costly mistakes or missed protections. For example, a tenant in Los Angeles might be covered by stricter city eviction protections, while someone just a few miles away in a neighboring city may only have the baseline state rules. Add pandemic-era law expirations, exemptions for newer buildings, and loopholes in just cause evictions, and suddenly, what seems straightforward becomes a maze. Navigating this without reliable information can feel like walking blindfolded through a minefield. So, what can tenants do to protect themselves? First, research your specific city and county regulations. Don't rely solely on general statewide advice. Second, keep up to date records of your lease, rent payments, and communication with your landlord. Third, consider consulting tenant advocacy organizations or housing attorneys if you're unsure. Even attending a free housing clinic can provide clarity and peace of mind. The reality is clear. Ignorance isn't bliss when it comes to housing laws. Staying informed isn't optional, it's essential. The more you understand, the better you can protect your home, finances, and overall stability. Knowledge isn't just power. In today's market, it's protection. If you've ever felt confused by California's rental laws, comment legal maze below. We are curious how many renters feel overwhelmed. We put serious effort into researching and simplifying these updates for you. So if this video helps, hit subscribe. It's just one click and it ensures you won't miss future insights that could protect your home. California's rental landscape is changing faster than many tenants realize. From steep rent increases and shorter notice periods to expiring local protections and stricter tenant screening, renters face challenges that can hit both their wallets and their peace of mind. The law may offer some protections, but navigating statewide regulations, city ordinances, and loopholes requires vigilance. Ignorance is costly, but being informed is empowering. The key takeaway is that proactive action is your best defense. Start by understanding the rules that apply to your specific situation. Know whether your building is subject to rent control, check local protections, and clarify your lease type. Keep detailed records of payments, communications, and notices. These small steps can make a big difference if a dispute arises. The financial preparedness is equally crucial. Build a housing emergency fund, monitor potential rent increases, and plan for upfront costs like deposits or moving expenses. These measures give you flexibility and reduce stress when unexpected changes occur. Communication and negotiation are also powerful tools. Discuss lease extensions, confirm rent caps, and clarify notice periods with your landlord. Being informed and polite but firm can sometimes prevent problems before they start. Finally, don't hesitate to seek help. Tenant advocacy groups, housing clinics, and legal advisors are there to guide you through the complexities of California's rental laws. Being proactive, prepared, and informed turns uncertainty into security. California tenants may face challenges, but knowledge and preparation are your strongest allies. But by understanding the rules, planning ahead, and staying engaged with your housing situation, you can protect your home, your finances, and your peace of mind. In today's unpredictable rental market, staying ahead isn't just smart, it's essential. If this video helped you feel more prepared, comment ready below and share your experience. We read every single one. We put serious effort into breaking down these rules for you. So if you value that, hit subscribe. It's just one click and it ensures you won't miss future updates that could protect your home.